Picture this. You're conducting a routine neighborhood patrol when you see a vehicle swerving and applying its brakes multiple times. After observing the erratic behavior for a few minutes, you decide to perform a traffic stop. You approach the vehicle and begin talking with the driver. During the interaction, you notice slurred speech, rapid blinking, and a distinct odor. She states that she had just one drink and is on her way home. You notice she's having trouble standing, so you conduct a field sobriety test. The driver doesn't perform well at all. As you continue talking with the driver, she states that she may have had 2 or 3 drinks, but that was earlier in the evening, and she'd eaten between drinks as well. When pressed, she can't remember what time earlier in the night was. You conclude the intoxication level is above the legal limit, so you make an arrest. You transport the arrestee to the station, read the chemical rights form, and instruct her to blow into the intoxilizer. At that point, the arrestee says that her brother-in-law is an attorney and has always told her not to blow, and it's her right to refuse. If this happened to you, what would you do? Would you simply give up and release the driver? The answer, of course, is no, and that's where the No Refusal initiative comes in. Many people think that the only solution for addressing a DWI suspect who refuses to provide a breath test is to suspend their license and fine them under implied consent. But that's not true. First, let's have a short lesson on implied consent, and then we'll discuss how officers can deal with a breath test refusal. Implied consent is defined as permission which is not explicitly granted by a person. Implied consent is relevant to impaired driving because every motorist agrees to a test of his breath to determine its drug or alcohol content when there is probable cause to presume he is operating a vehicle under the influence. In return, the state allows a motorist to exercise the privilege of driving. Under Louisiana law, a person with or without a driver's license who operates a vehicle on a public highway implies consent to being tested for intoxication. The term operating is broader than driving because the vehicle does not have to be in motion to operate it. Further, when a person applies for a driver's license, his signature on the application designates certain things, one of which is providing his or her expressed consent to be breath tested to determine if he is under the influence while operating a vehicle on public highways. Although every driver is deemed to give consent to a chemical test, the legislature allows the driver to refuse to submit, meaning he or she actually withdraws implied consent, but only after being advised of the penalties for withdrawing that consent. So the implied consent law does not provide an impaired driver any right to refuse the gathering of evidence of a crime, such as alcohol or other drug use. Rather, the implied consent law does the opposite. It implies a suspect's consent to a search in certain cases. Why do suspects refuse testing? Many DWI suspects refuse to submit to a breath test in the hopes that they will receive only a minor administrative penalty. They want to avoid the critical sanctions associated with a real DWI conviction. This is why we want law enforcement to look to No Refusal to combat DWIs and breath test refusals. Let's hear from Norma Dubois, a prosecutor with the Jefferson Parish District Attorney's Office. Norma explains further in the following clip.
Implied consent was created as a tool for law enforcement to help you gather the evidence. How many of you knew that? Most people have turned it around and think that it's a right of a driver to refuse, and it's not. Remember I told you about the U.S. Constitution, the Fourth Amendment, that you are able to, with a search warrant, search. And when we're talking about taking blood from somebody, that is a search. You're invading their body, and that is a search under the Fourth Amendment. And Alcazar is a state case that talks about the fact that it is a search of someone's body. So the Fourth Amendment applies. So the only way that you can do a warrantless search is if you have some sort of exception, exigent circumstances. The evidence is about to be destroyed. And remember I talked about consent? There's many more. But consent is one of them, and that's what implied consent was. It was an exception to the warrant requirement by providing law enforcement the tool that if the person got pulled over, they impliedly consented to having their blood, breath, or urine tested.
So now that we're clear on implied consent, let's discuss the lawfulness of search and seizure. Search and seizure is relevant in impaired driving cases for these reasons. After a DWI arrest has occurred and the defendant refused the breath test, or a defendant submits to a breath test and blows under the legal limit, but the officer suspects drug impairment. The Fourth Amendment to the U.S. Constitution provides for the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Further, it says that no warrants shall be issued for search and seizure except with probable cause. A warrantless search is considered reasonable only if it falls within one of the exceptions to the warrant requirement. For impaired driving cases, the relevant exceptions are exigency, consent, and search incident to arrest. Under a U.S. Supreme Court ruling made in Birchfield v. North Dakota, it was determined that an officer is permitted to conduct a breath test on an intoxicated driver without a warrant because breath tests, quote, do not implicate significant privacy concerns, end quote. The ruling went on to state that, quote, blood tests are significantly more intrusive than breath tests, and their reasonableness must be judged in light of the availability of the less invasive alternate breath test. In cases where blood tests might be preferable, nothing prevents the police from seeking a warrant or from relying on the exigent circumstances exception if it applies, end quote. Translation: an officer shall obtain a blood test to determine impairment, but must obtain a search warrant first, unless one of the warrant exceptions is present. Likewise, Article 1, Section 5 of the Louisiana Constitution allows for search and seizure. It was upheld by the case State of Louisiana versus Alcazar, in which the choice of a person under arrest for operating a vehicle while intoxicated to refuse to submit to a chemical test is not a constitutionally protected right. A later case, the State of Louisiana versus Clark, further confirmed that a court-ordered blood test designed to gather evidence against a person constitutes a search and seizure under the Fourth Amendment. Therefore, to survive constitutional scrutiny, a blood test must be conducted pursuant to a warrant based on probable cause absent a recognized exception. Additionally, various court cases have interpreted the U.S. and Louisiana constitutions to affirm that taking blood to determine impairment of an arrestee who has refused a breath test does not violate the defendant's right to due process, does not violate the defendant's right against self-incrimination, and does not violate the defendant's right to counsel during the actual blood draw. The court held that, while a defendant has a right to consult a lawyer, he does not have a right to wait to take a blood alcohol test until after he has consulted that attorney. At this point, it may be even harder to imagine how an impaired driver could refuse a chemical test and not experience any consequences. And, as a result, the idea behind the No Refusal initiative. The concept of no refusal ensures that law enforcement have the support in place to conduct a chemical test on an impaired driver after he refuses the officer's initial request to blow in the intoxilizer. Let's take a look at a typical protocol for how no refusal should be implemented. Think about a DWI stop. What does that typically look like? An officer has reasonable and articulable suspicion that criminal activity is or has occurred, so he conducts a traffic stop. During conversation, he determines impairment and makes an arrest. Once the individual is in custody, the officer transports him to the office and informs him about his rights related to the chemical test under implied consent. The arrestee refuses the test. It's at this point that the No Refusal initiative comes into play. There's no need to make a big fuss or production. There's not even a need to inform the arrestee of your next actions. Simply step away from him and follow your department protocol for obtaining a search warrant. Typically, that starts with completing an affidavit and search warrant for a blood draw. Now, depending on your agency's protocol for obtaining warrants, the process may vary slightly. Some agencies use an e-warrant system, while others still apply for warrants by phone and fax or even in person. We will address each process here. For officers who are at agencies that use e-warrant applications, here is what you should do. The officer completes the necessary fields within the e-warrant form to develop an affidavit and search warrant application. The affidavit is the equivalent to electronic testimony under Louisiana's Code of Criminal Procedure, Article 162.2. Therefore, the officer does not need to be sworn in by a judge or magistrate. The warrant is electronically delivered to the judge or magistrate by web. Now, depending upon a judge's preference, the officer may need to text or email the judge to inform him that an e-warrant has been submitted. The judge reviews the e-warrant, and if approved, he attaches an e-signature and submits the return electronically to the officer. The officer is informed by email notification that the e-warrant has been signed. The officer should then proceed to step 8 at this time. For officers at agencies using fax or email warrant applications, the officer calls the judge and advises him or her about the warrant. The judge administers the oath and swears in the officer over the phone. This procedure is in line with Louisiana Code of Criminal Procedure, Article 162.1. Once the officer has been sworn, he signs the affidavit and faxes or emails it along with the warrant application to the judge. The judge reviews the warrant. If approved, he signs it and faxes or emails the warrant back to the officer. The officer should proceed to step 8 at this time. Please note that this part of the protocol is very similar for agencies that apply for warrants in person. At step 8, we are back to the same protocol for all agencies. The officer serves the arrestee and reads the judge's order to submit to a chemical test. At this point, it's likely that the arrestee will protest, either verbally or physically. Remember that the search warrant provides you cover to proceed with the blood draw. If the arrestee offers to blow in the intoxilizer at this point, let him do the breath test, but still follow through with the warrant. More evidence is better for the case. If the arrestee demands an attorney, remember that while the Constitution provides for a right to legal representation, it does not require that an attorney be present at the time of the blood draw. Additionally, Louisiana Code of Criminal Procedures Article 164 outlines provisions for the use of reasonable force in executing a search warrant in the event that the arrestee becomes physically combative. Louisiana Revised Statute 14.108 makes it a criminal offense to resist an officer who is attempting to execute a search warrant. Decisions in several court cases have upheld the use of reasonable force in such situations. The officer has a couple of options for conducting the blood draw. He can either have medical personnel at the correctional facility draw the blood, or if none are available, he can summon an EMS provider. Only as a last resort should the officer transport the arrestee to a hospital for a blood draw. When a search warrant for blood has been issued, there are various Louisiana laws both protecting the medical personnel from liability for conducting the draw and also compelling them to do so upon request from law enforcement. For printable copies of this protocol, visit the website for the Louisiana Highway Safety Commission at www.lahighwaysafety.org and search No Refusal. As sources of evidence of DWI, breath, blood, and urine build on each other to help make a strong case. Breath is easiest to obtain due to court rulings. However, once a breath test refusal occurs, we want to encourage officers to apply for a search warrant to obtain blood in addition to or instead of making a request for breath or urine. There are a few simple but important reasons why blood is considered the best evidence possible in these cases. The first reason is blood tests provide more detailed results. Breath tests cannot detect drugs, and urine tests cannot detect alcohol that correlates to impairment. The second reason is illicit and prescription drugs are increasingly becoming major contributors to impairment. The final reason is because urine provides past history of drug use only, while blood is what's in the brain at the time of the blood draw. Urine samples by themselves, without accompanying blood samples from the arrestee, can create obstacles during trial and are not preferred by the LSP crime lab. It is important to note that the only blood collection kits to be used for DWI evidence collection are the ones approved by the Department of Public Safety. Those are the BU-0LA kits for live subjects and the PM-0LA kits for deceased subjects. A complete list of approved blood kits is available on the resource website noted at the end of this video. The No Refusal initiative isn't only for obtaining blood tests, but if you're going to go through the process to get a search warrant, you might as well collect the best evidence possible, which, for DWIs, is blood. Here's Norma again, talking about why the Jefferson Parish No Refusal initiative prefers blood to breath.
Now let's talk a little bit about, I prefer to get blood anyway, because I can tell you one of the things that Major Sazon and I are really working and focusing on right now is drug driving. As a prosecutor, I get to see a lot of these cases. I look at every felony DWI that comes into our office, and I can tell you that probably over 40% of those cases are not alcohol. There's some other form of drug. And so if you're only getting an intoxilizer reading, you're not capturing every person. So for me personally, blood is much better, because then I can figure out if you have alcohol or if you have other drugs. Drug driving is a huge problem, and we really need to get a handle on it.
Think back to the procedure we outlined a moment ago. Seems like we need involvement from some additional stakeholders, right? We need judges and EMS on board to ensure the process is as smooth and speedy as we need it to be, especially with the dissipation of alcohol in the blood. If you're watching this video, chances are good that your superiors in the police department have collaborated with the DA's office, local judges, and medical personnel to gain their support before training you on it. However, please be sure to ask your superiors for contact information for specific judges and medical personnel who have signed on to support the No Refusal initiative. Even with committed support, medical personnel may need encouragement. Remind them that this may be a new process, but not a new law. For example, medical personnel may need to be reminded to use the correct blood collection kits, and only the content of those kits. Additionally, you may have to remind them that 2 full tubes of blood, 20 milliliters to be exact, need to be collected. Also, they should be reassured that they are protected by law from criminal or civil liability for conducting blood draws under a warrant or at the behest of a law enforcement official. The most common question we get from police about no refusal pertains to whether it is considered coercion if they tell a defendant who refused to blow that they are going to obtain a search warrant. The short but final answer is no, it's not. Legal experts and law enforcement officers agree that it's best not to even mention to the suspect any intention to obtain a search warrant if he or she doesn't blow in the intoxilizer. Then there is absolutely no act of persuasion by force or threat occurring. Simply step away from the suspect and follow your department protocol for obtaining a search warrant. If asked directly by a suspect about what will happen if he or she doesn't blow, reply succinctly and truthfully by describing your department protocol for applying for a warrant, but make it clear that it's ultimately up to the judge to determine whether there is sufficient cause for a court order. Your best protection is to follow your usual department protocol and practice when dealing with a difficult suspect. This concludes our lesson on using search warrants in situations when a breath test refusal occurs. Examples of the probable cause affidavit The search warrant, the return, and an officer protocol are available on the web. Go to the website for the Louisiana Highway Safety Commission, www.lahighwaysafety.org, and type "No Refusal" in the search box. If you still have questions, please feel free to contact the Louisiana Highway Safety Commission directly. Thank you for your efforts to make Louisiana's roadways safer.